Thank you very much, Mr. Chairman. Professor Gluck, let me start with you, because you said something extraordinary, which is that your partner in filing an amicus brief against this attempt to destroy the Affordable Care Act and strip 20 million people of their health insurance is a person who was opposed to the Affordable Care Act and was your nemesis, essentially, your counterpart on behalf of the Affordable Care Act back in the Burwell case. Is that right?
Yes, it is. It is extraordinary.
So you're talking about a distinguished lawyer who was opposed to the Affordable Care Act and thought it was originally unconstitutional, but he thinks it would be absolutely absurd and outrageous to use the invalidation of one provision, which zeroed out the penalty for not purchasing insurance, to unravel the entire act. Is that right?
Correct.
And you cite a bunch of other conservative legal scholars who are on that side. Would you repeat some of the ones you mentioned?
Sure. Well, there's the Republican attorneys general from Montana and Ohio, Judge Mike McConnell.
Judge McConnell?
Yes. Professor Sam Bray, Professor Kevin Walsh.
In what context is Judge McConnell taking a position against the administration's point of view here?
Judge McConnell authored an amicus brief with two other noted conservative legal scholars arguing that there's no jurisdiction to decide the case and filed a brief not on behalf of neither party, but actually on behalf of the blue states.
Okay, I want you to underscore this point for our colleagues. Obviously, we have a difference about whether or not 20 million people should be stripped of their health insurance and about the general progress we've made under the Affordable Care Act. But let's just go to the point about legal severability. In 2017, there were efforts to repeal the whole Affordable Care Act. I remember that. I was in Congress then, and they had voted 69 different times to repeal the Affordable Care Act in its entirety. They weren't able to do it because there was a mass uprising around the country. I remember people went out to all the town hall meetings and said, don't do this. The eloquent, riveting testimony like the kind we've heard today from patients, don't do this to our families. And they weren't able to get enough Republicans to do it, even though the Republicans controlled a majority, right? So instead, they passed this one provision, zeroing out the penalty on the compulsory purchase of insurance policy, right? That was it. And at that point, everybody agreed that the Affordable Care Act should be saved. Some people thought it was a great thing. Some people thought it was a terrible thing. But now, there's the proposition being pushed by, I don't even want to say conservative Republicans, because a lot of conservative Republicans on our side, but by an extreme faction, apparently within the Trump administration. There's a position that the invalidation of this one provision, or I don't know if it's the passage of this one provision, but undoes the entire act, so undoes everything. The protection for 26-year-olds, pre-existing condition coverage, all of the Medicaid provisions, all the provisions that expand people's access to prescription drug benefits, closing of the donut hole, everything that's in there, they're saying is now toppled because this one provision is gone. Now, what does that do to the power of Congress? When we thought we were passing one thing, and now the courts say, well, because this one provision is out, we're going to strike down a 2,000-page piece of legislation.
Yeah, I think one of the reasons you see this unprecedented consensus, you're absolutely right, that this case goes to the power of Congress. To let the court do what it did here, the court is taking over congressional lawmaking power. The court is being activist. It's usurping congressional lawmaking power. Conservative legal scholars and liberal legal scholars alike value separation of powers.
I wouldn't even want to win that way. In other words, if I thought that the Affordable Care Act was the creature of the devil himself, and I wasn't able to get it through Congress, but we were just able to chip off a little piece of it, and then later some judges say, hey, we're going to go ahead and destroy the entire act, I wouldn't support that, because that is an absolute defeat of legislative power, isn't it?
Well, yeah, that's what the Wall Street Journal editorial page said. It started saying nobody hates Obamacare more than we do, but this is a corruption of the rule of law.
What are some of the other things that would fall if the administration now gets its position in destroying the ACA?
Well, I don't think it can be overstated, the reach of the statute. I mean, we've got Medicare prescription drugs, we've got no discrimination based on health status, we've got the Indian health care program, we've got the FDA approvals for biosimilars.
But they would invite us to believe that we all knew that when that vote took place, that we were essentially going to undo it if one phrase or one sentence dropped out of the legislation.
Courts are actually, respectfully, not allowed to do that. Courts are not allowed to presume that the legislature sowed the seeds of its own destruction into a statute. Courts have to interpret statutes deferring to the legislature.
Well, thank you for what you're doing, and thank you for reaching across the aisle to bring conservative scholars in and to work with them on defending this critical principle of the severability of provisions that are struck down by a court.
Thank you.
I yield back, Mr. Chairman.